Oh, I'm sorry.
879. For delivery of judgment, WBC 8794/19.
Impugn opinion dated 4/10/2019 passed by the Foreigners Tribunal is upheld and confirmed. The writ petition stands dismissed and disposed of.
Most of it. Oh,
Nine. 4%.
wait, please. My lord, I'm mentioning item number 42, my lord. Here I appear for the respondent. Having gone to the, my lord, writ appeal, I find annexures are not annexed, my lord. Those are very vital, my lord.
Not there.
Not there. There are, in fact, it's a very protected litigation, my lord. Several rounds of litigation are there. I don't find the annexures annexed to the affidavit. It will be very difficult to refer.
In the affidavit, we have not annexed, my lord, but is it proper? Will you like it? If you stand here in place of Mr. Chaudhary, will you like it? Bring it on record. By the affidavit. Yes.
That's all, my lord. Only
There is
that pagination will change.
There is a small term which is called ease of doing business.
Ease of doing.
Famous term. And we should in fact thank Mr. Chaudhary because he has not opposed the admissibility of the writ appeal on that ground. Would have affected you. Incomplete memo appeal cannot be admitted. Item number 42.
Yes.
Authorized are represented. Mr. K. N. Chaudhary, Leonard, Senior Counsel, Senior Counsel for the caveator.
Or respondent number 8.
Caveator, oblique respondent number 8 submits that the memo appeal is incomplete. Next, Mr. D.J. Mehdi, Leonard Counsel for the appellant, and next to bring the missing annexures on record by way of an affidavit. Mr. Chaudhary,
Yeah.
Instead of that renumbering of the pages, it can be in seriatim to the memo appeal.
I think that will be better.
Otherwise, it's very difficult. He'll have to sign all the documents and
So
then.
therefore, it will be volume 1, that will be volume 2. That's all.
If I may be permitted to file an additional affidavit. That's what we are saying. That's what we are saying. Otherwise, you'll have to have it inserted in the middle, which will be very difficult for you. It will cause you too much of trouble by way of an additional affidavit. List on well. Okay. Then we say that list as and when the additional affidavit is filed.
Miller. Deeply.
If it is not listed, make a mention.
Miller.
Yes.
My lord, I have filed an IA in review petition, my lord.
Edit.
I need to mention in respect of item number 16, 25, and 32, your lordship. And this counsel is Mr. S. Howe.
16.
16, 25, and 32.
You have to wait for some time because 16 is 2019.
Number
16, then
25,
25 is again 2017.
and then
Very old.
32.
32 is again 2019. You'll have to wait till the matter is
I am
called.
not engaged counsel in this case, my lord.
It's okay, ask somebody to be here, but we are not adjourning old matters.
Doctor suggested him to take bed rest, your lordship.
No, we are not saying we are refusing it,
Madam,
but let the matter be called. We'll have to see and pass on this.
no suppose.
Ask somebody to be here. You may not be here.
No.
We'll just make a note, even if you are not there. Item number 32, then
25, then 16.
25 and
16.
16. We'll have to look at the records and then pass orders. Old matters we are not adjourning.
Yes, Lordship. First, we have victimization item number 41, Lordship.
Item
41, Lordship.
41.
Yes, Lordship. Actually, there is some technical defect in the Lordship, so I want to do it and to refile it, Lordship. 41, Lordship. Some technical mistake is there, Lordship, so I want to do a refile, Lordship.
TCR is there,
Yes,
Lordship.
TCR is there, so it can be,
Records
Lordship.
have come now at this stage. This could have been, this.
Oh, records are there.
Taken up, yes,
They could be there,
Lordship.
Lordship. Immediately, I can refile, Lordship, then, so again, I can, Lordship, take this answer, Lordship.
At the motion stage, if this plea was taken, Lordship, it would have been better.
Just say, I don't know, 41.
The record has to be retained. It
This is it,
I'll say it again.
Lordship, then it will be.
can be retained.
What is the defect?
Actually, voter list of 56, there are two voter list, Lordship, but which one I have annexed here, Lordship. Data is the LCL, Lordship. It is another certificate we have, Lordship, there in their LCL, Lordship. Lordship, once, Lordship, it may come for objection, Lordship, this voter list will tell you that, Lordship.
Maybe after checking the LCR, he has realized it.
Yes, Lordship, that's correct, Lordship. They collected two voter list, Lordship. But they cannot say, Lordship, what is the.
Bring it by way of an affidavit
Yes.
instead of withdrawing.
Can file
If objection
additional-
cannot come, Lordship, then I have no objection, Lordship.
Additional.
Hmm?
If they have not raised an objection, Lordship, that this can also accepted, no, I have no issue, Lordship.
We will
After
go by the
they can say-
records, Lordship. We have
Yeah,
nothing
going by the
personal to
records.
make an objection.
You always go by the records. You bring it by way of an affidavit.
Yes, Lordship, that's the issue.
It's easier because otherwise, again, to retain the records on a.
The vital document, Lordship,
on a-
that means
To bring
the objection.
additional evidence. Faster.
By way of additional affidavit, Lordship.
Both sides are represented on the pair Midland as how planning council petitioner is permitted to bring the correct voter list of 1966 on record by way of an affidavit. List as well as the affidavit is found.
Always right.
For motion, item 1 with item 2.
May it please, Lordship.
Lordship, Mr. Powell would be appearing in these matters. So maybe fix that too, Lordship.
Not, I have a small prayer, my lord, please. Lord, my lord would remember, my lord, this case, my lord had pointed out section 90 of the Evidence Act would be applicable. Lord. I was,
Matter in the context, then I may recollect.
my lord, if it can be taken upon, my lord, I need to study a little bit more on the section 90 part, my lord. If it can be taken on the upcoming Saturday, my lord. Otherwise, my lord,
Saturday,
the work
I
is
will
Saturday,
not
my
be
lord,
here.
on the 1st of August, my lord, if it is not inconvenient, my lord.
We take it up on 28th then, it will be.
28th,
My lord, can I go on 29th or 20 or 30, my lord?
29th is a motion day, we have made a lot of motions on that.
30th, my lord,
30,
30, my lord.
okay.
Deeply.
What says represented or the prayer made by Mr. A.D. Dale and counsel for the petitioner. List the matter on 27/2026. Here, there are two records.
Yes, my lord. Item 1 and 2 are
Item one and
part
two.
of same judgment, my lord.
Okay.
brothers, no?
Brother,
The brothers.
brother,
Lordship.
brother.
Okay.
Deeply, my lord.
Item 3 for motion.
Yes, your lordship, the matter will be heard after some time. Senior is in another court.
Lordship, I'm not sure if notice has been issued in item 3, Lordship.
No, not issued, not issued.
Lordship may issue notice and fix it up for admission hearing, Lordship.
TCR has been received.
Yes, so it can be taken up.
It's 1 and 2.
No, Lordship, 3.
Just a moment. Just a moment.
Yes, Father. Yes, no.
We'll hear the learning council, these are next, let him come. I couldn't hide this was
Please time being, Lordship.
for the timing.
Item 4.
Applicable.
Yes,
But this is an expertise order, lordship.
which page?
Lordship, case 28, lordship. And lordship, page 24 is the post server report, lordship. 24.
Her name is not Javid on paper.
Yes, lordship.
And that's why, Lordship, on 4/12/2020, this honorable court has directed to Lordship State to file affidavit, Lordship. And till date, Lordship, no affidavit has been filed.
Lordship, maybe we missed it out, we'll file it, Lordship. We'll get a report from the police whether she's one and the same person, and we'll file it.
Jabiran Deva alias Maziran Deva.
Mazirans.
And but in the petition, he has written alias as Jabiran. He accepts both the names, Lordship.
Jabiran Deva.
No, Maziran.
Maziran.
But this plea was not taken up, it seems, during the proceeding, Lordship.
Lordship, in this process of a report, it is mentions, Lordship, that I am not Zaviran. I am Maziran. All the documents showing I am Maziran. So that's why he
Unfortunately, we read page 10
Okay.
of the petition.
Husband's name would have been same. Yes, Lordship.
Lordship, I am alias, Lordship, as
I don't know if it is obvious that.
Lordship, in my petitions,
Petition also, that is what I mentioned,
Lordship,
Lordship.
in petitions, I have categorically mentioned that my name is not.
I don't know, page 10, you'll have to overcome that. We have certain limitations in our understanding.
Then, Lordship, one point may be considered, Lordship. If I have categorically mentioned in my petitions, Lordship, kindly come into case, Lordship.
Actually, in the affidavit also the person should stick to, I claim this to be my name.
Lordship.
I should stick to that, right?
Yep.
I did. File affidavit also. Alias is by the other person. I don't say that I have an alias, but I'm not saying so.
Yes,
I should stick to my name.
yes.
And whether the husband's name is same or not, Lordship. Some
Page 7, paragraph 10, Lordship. Paragraph 14, I have misstated, Lordship.
You see, in your petition, there is no statement that in your village, there is no person, there is another person named Kandura.
Yes.
Kandura is your husband.
Lordship.
In page 10, your affidavit, you say Majiran Beva alias Jabiran Beva, and then you say you are wife of Kandura.
Lordship, as we go, Lordship, I
And
would,
in your village, you don't say that there are a lot of Kanduras and therefore.
Lordship, as because I am not aware whether same person is there or not, Lordship. So that's
No,
why,
you see, in your village, everybody knows everyone.
Lordship. Lordship, my limited submissions, Lordship. Why I am submitting, Lordship? As because my name is Maziram, and in my name is still I am market defaulters. So, Lordship, whether there is another case also may be pending, and Jabiran is another case may be pending. So that's why, Lordship, in the last operations, Lordship, on the 4/12/2020.
No, you are the same person. Now you are
but-
creating an ideas because in the voters list, your name appears as Jabiran,
No, Maziran, Lordship.
but that voter list have you next year?
Yes.
it's a voter of 2010, Lordship.
So that's why, Lordship.
Kandura.
Lordship, page 13, there is the concise certificate, Lordship. Then subsequently voter list, Lordship.
Lordship, may I just go through the records? I want to see what name was given when the inquiry was
Just a moment.
taken. Yes, Lordship.
Any voters list prior to 2005?
Lordship, no lordship.
That is the only voter list.
2005 voter list, so that is page 14. Vernacular page 15, lordship.
Yes, sir, you know.
There is, yeah, I have also gone through this format of the verification report, Lordship. There is a catch. Her date of birth is shown as 1162. That means she would, as on today, she would have been 64 years. But affidavit states she's 45 years. And that husband is not there right from the verification report. Here also it is late. Late Pandura Sheikh, at page, this verification, page 21, Lordship.
Yes.
So whether Jabiran and Majiran, one person is there, but projected husband was never alive, Lordship. So it may be possible that the husband's name has been used by one of these women. Either
No,
Majiran
because
or
you see,
Jabiran.
he's, come to page 15 of the petition,
1-4, Lordship.
1-5.
Yes, Lordship.
At page 15,
Yes,
serial number 586 is this Majiran Deva.
yes,
Husband is Kandura Sheikh.
yes,
Age is 35 years. That
Yes.
will make the year of birth as 1970.
year of birth would be, this is on
1970.
1970, yes.
Now, you see, instead of viewing it in that way, this is a reference by ERO. That means it will have an effect on the voters list,
Yes,
and therefore demark has been given.
And right from the beginning,
Wait, that's okay.
yes.
A demarc has been given. So the demarc is of Moziram. If you want to make an inquiry, you have to get the voters list of 1997 onwards and then check up whether it is the same or there are two people.
And 66 also, Lordship, the connect with the parents is not there. No mention.
No, we are not on
There's
that.
only one voters
No,
list.
we are not on that. If that be so, then perhaps she has a good reason not to appear.
Yes.
So therefore, it will be a case of remand. So if you want to make an inquiry, you can ask the border police to have the voters list checked. If in the village, there are two lady, one is Majiran Deva and one is
Jabiran.
Javiran, who
And
are both D voters.
And who are both have one husband. The name of the husband is same.
Same.
Then it will be a subject of confusion.
Then it will be a subject of deliberation. Then we will
If it
inquire.
is reflected in the order will instruction. This is a very common case, Lordship, using the names and outline typographical error here and there. Just
But-
to have a linkage.
Heard Mr. I. Hawk, learned counsel for the petitioner. And so for the respondents. Next para. The learned counsel for the petitioner, by relying on the voters list of 2005, submits that the correct name of the petitioner is Majiron, Majiron, Majiron Deva, wife of Chandura Sheikh. But as notice was issued in the name of
Jabiran.
in the name of Jabiran Deva, Jabira, who inadvertently did not appear in contested proceedings. Next para. The learned study was for the border and FT matters has submitted that on a comparative reading of the age disclosed by the petitioner in the affidavit filed in support of this writ petition, and age as disclosed in the format for verification officer's report, and the voters of 2005, which is the next in the writ petition, there are some variations in the age. Stop. Next one, accordingly, she prays for some time to get instructions from the
SP Lordship.
Superintendent of Police within bracket border, Dhubri,
Dubri.
and to file an affidavit if required. In the event, there are two separate persons with the
Whether
Common-
Majiran and Jabiran are one and the same, Lordship.
we are not saying that.
No, let us find it out.
We'll find out.
Yes,
With
Lordship.
having a husband with similar name of Kandura Sheikh. Stop. Next one, contestants adjourned today. Next one, this on, we are giving a date after 10, 15 days, 15 days. Give date after 15 days.
10th of August.
Before that, you say that the Learned Standing Counsel for the Border and FT matters is permitted to send a downloaded copy of this order to the concerned authorities. List also, sir.
Extra copy may be served, lordship, and the soft copy.
Lordship, in this case, Lordship, just one observation may be given, Lordship, whether any case pending in the name of Nazir or not, Lordship.
This we don't know.
As because, Lordship, I am the Nazir, if I am another proceeding is pending in my name, and the two court proceeding will be comes, Lordship. In future, I will be,
We'll get the information.
Lordship.
Lordship, we cannot get that information, in which district they went, where they inquiry
Right,
was
that-
held, and again they
that-
come back.
Either in that district only.
In that case, yes, Lordship.
In the-
That
So
district.
I think he's aware that there is a proceeding.
We don't know. He is just asking. We take certain things on face value.
Name is like main problem.
Because he thinks that if there is any Maziro and there is another proceeding,
Yes,
if
Lord.
he knows, does not know,
Yes, Lordship.
then he'll have to file another writ petition. That's
Lordship.
what he's saying.
Lordship.
Lordship, in the document which he has annexed here, relating to his parents, there's only 166, voters list of 66. There is nothing else to show the connectivity. If the police inquiry goes,
So
they will have to look into subsequent earlier voters list also, lordship, her lineage with her parents, not with her husband.
Lordship, this is an expertise order, Lordship. Lordship is,
No, they will find it out because of
Lordship.
the fact that they are specialized police for the purpose of investigation in these matters.
Lordship.
And this is a case of reference by ERO.
Yeah.
In 1997, they did the draft course of 1/1/1997. So definitely, if it is D-voter, that effect will come in that voter list of 1997.
Let us
If
try,
you call-
lordship. Otherwise we'll take the help of ECI if it is not possible. We will do that. Lordship has fixed a date for
Yes.
Timing item 3.
Okay, in this matter, I pray for taking some instructions as of today. The matter has come after 2019 and she is 80 years old. And I've heard from the villagers to expire, but I'm not confirmed. Worship will give me 2 weeks time so that I can get the instruction moving.
That's about the death certificate.
Yes, sir. Without knowing the, getting the recipe, I cannot assure that like expired.
Mr. S. Ahmed, and counsel for the petitioner, pays for some more time to obtain the death certificate of the petitioner. To stop. Matters will adjourn today. List on, due date after 4 weeks. List on so. Next para. It is made clear that if the death certificate is not received, the court will proceed to hear and dispose of the matter on merit. Next para, list on.
24th of August.
Okay.
Item 5.
Yes.
Victory, your lordship. Lordship, the impugn order is on page 80, your lordship. Your lordship, the petitioners has exhibited, your lordship, the Jamabandi SL date prior to the cutoff date, Your Lordship, and she has also exhibited the voter list of 1966, wherein her parents' name were enlisted in Your Lordship. Thereafter, the voter list of 1985, 2015, and 2018, Your Lordship. And Your Lordship, the mother of the petitioner name can be found in all the voter lists till 2018, Your Lordship. He appeared before the tribunal as DW2 and before Your Lordship. And Your Lordship, what is Your Lordship? What can be found out from the verification report, Your Lordship, which is from page 45? It has been clearly stated that she was born in the district of Nagaon, Kolopia, in the district of Nagaon. And Your Lordship, it has, and Your Lordship, going by her, Your Lordship, affidavit, she was born in the year 1961, Your Lordship. And Your Lordship, no materials can be seen, Your Lordship. The verification report is completely blank, Your Lordship. Her name has been written. Her father is a voter. That has been marked as yes. And she was born in the district of Nagaon, Kolopia. And as of 2019, she was 61 years old. 58 years old. So, Your Lordship, going by that, Your Lordship.
No, but how did you prove the link between your projected parents and yourself?
Your Lordship, the thing is that, Your Lordship, my name appeared, my parents' name appeared in the voter list of 1966. Your Lordship will find
What is the name of your father?
Syed Ali, page 2930, Your Lordship. And mother's name is Rupjan, Your Lordship.
And you said that you had a land of prior to that.
Yes, Your Lordship.
Who is the, you are the
Your
purchaser
Lordship,
or the?
my grandfather's name, Nawab Ali, Your Lordship. That is of the year 1955, Your Lordship.
But then there is no link between Nawab Ali and your father and.
Your Lordship, my
Okay.
parents' name appeared in the voter list of 1966, Your Lordship. And prior to that, Your Lordship,
Is there any voter list of your father and your grandfather together?
no, Your Lordship.
And any voter list of you and your father together?
No, Your Lordship.
Mother.
No, Your Lordship. I got married, Your Lordship, when before the age of 18, Your Lordship. And but my mother's name appeared throughout till 2018, Your Lordship. I've exhibited those documents, Your Lordship. My mother appeared before the tribunal, Your Lordship, and before that I am her daughter, Your Lordship.
Where is the, just hold on.
Jamabandi is of 67, 68.
The year here is 1930-31, Your Lordship. The annexure 1. Hereafter, Your Lordship, there is another Jamabandi, Your Lordship. That is annexure 5. That is of 67, 68, Your Lordship.
Their grandfather's name is mentioned.
Son of Nawab Ali, yes, Your Lordship.
But you see the. You see, these documents
Lordship.
do not help you.
Lordship.
Though this is a Gauhati of 1931, 3031.
Lordship.
The reason is that this is a certified copy of the Jawabandi. It contains the name of one Nawab Ali.
Lordship.
But this land, we don't know the history of this land, whether this land went to your father or not, we don't know.
Yes, sir.
Whether you inherited a part of that land, we don't know.
Lordship.
Now, Jawabandi is something which, for which there is no restriction on anyone to get a certified copy. X may get the certified copy of Jawabandi of Y.
Lordship.
So how does it prove a link? Because that land was never inherited by you. The
Lordship.
second is
Yes, sir.
that you refer to the second Jawabandi.
Lordship.
That is Exhibit 5, and it is this is of
67.
67, 68.
Lordship.
Now, as far as this land is concerned, the document which is which was proved in original, this I am unable to read it. This we can't read. But in respect of this land also, we don't have its history as to whether this land devolved on you or not, and whether this is the same land which is reference of which is there in the Jahmadi of
1931.
1930-31,
Lordship.
which is Exhibit 2. Just see this record. We can't read it. If you can, please tell us. Put a flag on that document. And in this case, in order to get perfection, the case was destroyed. There was an overkill which destroyed the case. The fact is that the DW 3 or 4, the Gauhati is Gauhati is 4, I think.
Yes, sir. Lordship.
Yes. He gives a statement that he knows your father well. And the tribunal has arrived at a finding that this could not be because He was not alive at that time, and he was a resident of different village.
Lordship.
That finding, we are unable to
Your
see any
Lordship,
fault in that.
Your Lordship, it has been said that he knows my father since 1995. He has nowhere stated that he resided at that point of time in Alisinga, Your Lordship. So even if he had resided in a different village, he could know, Your Lordship. Your Lordship, what I am on, Your Lordship, even if we don't rely on this land documents, Your Lordship, though, which is visible is that, Your Lordship, both the lands, that is Annexure 1 and Annexure 5, Your Lordship, it belong to Modasil Puturi, Your Lordship. That is visible, Your Lordship. And even if I rely on the voter list of 1966, Your Lordship, this voter list are prior to 1971, Your Lordship, where my parents' name were enlisted as voters. Thereafter, Your Lordship, my parents' name were again enlisted together in the voter list of 1985, Your Lordship.
Well, how do you prove that he is your father?
The very fact that, Your Lordship, my mother, whose name was enlisted with my father in the voter list of 1966 and 1985, Your Lordship, she appeared before the tribunal, Your Lordship. She was around 80 years old, Your Lordship, when she appeared before the tribunal, Your Lordship. And Your Lordship, the foundation of a foreigner's tribunal case is the verification report, the inquiry report. There have been several allegations in foreigners tribunal cases, all that house-to-house inquiry is not done. But in this case, even if we rely on the inquiry report, Your Lordship will find the inquiry reports clearly suggest that, Your Lordship, the officer was satisfied because her name has been clearly stated. Her father, he was even able to find that her father is an elector, is a voter of India, Your Lordship. He even writes in the verification report that she was born in Holopia, Nagaon, Your Lordship. Your Lordship, on the basis of this report, Your Lordship, her name ought not to have been referred to the foreigners tribunal, Your Lordship. Verification. Yes.
Okay.
Yes, yes.
No documents produced. This is not a father's name.
Yes.
So
No, it has
how
been
can it connect her to the family?
And Your Lordship, there is another thing, Your Lordship, in the verification report, point number 15, whether migrated to Assam, it has been shown as no.
Lordship, this verification was done
Let
only
him
after.
complete.
Yes,
Let him complete, then we will continue. Yes. Yes.
Yes, Your Lordship. Your Lordship, another thing, Your Lordship, which the learned tribunal went on to say, Your Lordship, regarding the evidence of GW4, that he was not alive in the year 1995, Your Lordship, but in the cross, Your Lordship, deposition of the of DW and DW1 and DW2, both of them said, Your Lordship, that the father of the petitioner died in the year 2004, Your Lordship.
Yes. But apart from that statement, the presence of your father is only in the voters list of
Petition 85,
66 and
85.
85.
Your Lordship, 1985 voter list, Your Lordship, will find page 34, 35. Your Lordship. Your Lordship will find my written statement on page 51, Your Lordship. Date of death. Year of death, as per the deposition, it's 2004, Your Lordship.
Not mentioned in the W's lordship.
WS, it has not been mentioned in this. Your Lordship, as per the deposition, Your Lordship, he was married, Your Lordship, in the year 2019.
No, 1990, page 72.
Maybe it's her second marriage. Maybe. Just coming to the statement. Lordship, Your Lordship, the deposition here, Your Lordship, that she was married in the year 1990, Your Lordship. That is something, Your Lordship, that doesn't, Your Lordship, is in conformity with my instruction, Your Lordship. I actually, Your Lordship, going through this, Your Lordship, if Your Lordship go by her age, she was married in the at around 29 years of age, Your Lordship. So, Your Lordship, what I have been told, Your Lordship, she was married at a very young age, Your Lordship. I'm not sure whether it was a second marriage or something else, Your Lordship. That has not been brought into record, Your Lordship.
Wife of.
But we will get. Yes, the other person is the wife of Mujibur.
Very young looking.
That was in 2010. So, 1990. Lordship, I had exhibited, Your Lordship, 4 voter lists, and for linkage, Your Lordship, my mother appeared before the tribunal as DW2. I have exhibited a Gaubura certificate, Your Lordship, and Gaubara appeared before the tribunal as DW4, Your Lordship. These are the DW2 and DW4, Your Lordship. They are the only linkage with my parents, Your Lordship. Oh, DW2 is my mother, whose name appeared in the voter list of 1966 along with my father, and also in the voter list of 1985, Your Lordship. And DW4 is the Gaubara, Your Lordship. We appeared before the tribunal and deposed that I am the daughter of Sayyid Ali, Your Lordship. Your Lordship, my submission started with the inquiry report, Your Lordship. Your Lordship, for a tribunal, for a case to be referred to the foreigners tribunal, it has to be on the basis of a report by the concerned authorities, Your Lordship, be it the superintendent of police border or the election officer, Your Lordship. And in this report, it is clearly stated, Your Lordship, that she is Afiza Khatun and she has not migrated to Assam. And she was
That is the page.
Your Lordship will find from page 45. Your Lordship will find the original copy from page 49. Your Lordship will find that her name is Afiza Khatun, page 49 and lecture 13. Her address is Amguri PS, Thelamara. It's Sunitpur. Father's name, husband name is Mujibur, place of birth, Kholopia, Nagaon. And Your Lordship, if Your Lordship move on to point number 15, whether migrated to Assam, yes, has been cancelled, Your Lordship.
Case law according to this.
Yes, Your Lordship, I'm coming to the recent judgment, Your Lordship, the Savitri Day judgment, Your Lordship. I'm relying from para 11, Your Lordship. Your Lordship, even in the full bench judgment, Muslim Mandal and thereafter, Your Lordship, even in the Rahim Ali judgment, it has been clearly stated, Your Lordship, there is a burden of the state, Your Lordship, the initial burden of the state, Your Lordship. Some materials has to be there for a person to be referred, for his or her name to be referred to the foreigners tribunal. One cannot randomly go and, Your Lordship, refer anyone's name to the foreigners tribunal, Your Lordship. It has to be based on some certain reports, Your Lordship, certain inquiries, Your Lordship. And Your Lordship, I am relying on the recent judgment, Your Lordship, Savitri Day versus Union of India and others, civil appeal number 2820/2024, Your Lordship. Your Lordship, the recent judgment where, Your Lordship, the 27 cases were disposed of.
Which date?
This in case,
You referring to the ex parte?
yes.
But this is not ex parte, right?
These are not experts.
This is contested.
Paragraph.
Paragraph is from 11, Your Lordship.
11.
Yes, Your Lordship. A bare perusal of section 9 of the 1946 Act shows that it undoubtedly places the burden upon the proceeding to prove that he or she is not a foreigner. The provision is courts in clear terms and operates notwithstanding anything contained in the Indian Evidence Act 1872. The reason for such a statutory burden is also understandable. Facts relating to birth, parentage, residence, family lineage, migration if any, and documents supporting nationality are ordinarily matters within the special knowledge and custody of the person proceeded against. However, the existence of a statutory burden under Section 9 of the 1946 Act cannot be read to mean that the tribunal is relieved of its own obligation to conduct a lawful adjudication. Section 9 does not authorize a mechanical declaration. It does not permit the reference to be accepted as conclusive merely because it has been made. It has also does not permit the tribunal to treat absence of the proceeding as a substitute for examination of the material placed before it. The burden on the proceeding operates within a legal process. It does not reflect.
Yes, please.
Your Lordship, para 13, the burden under Section 9 of the 1946 Act must therefore be understood in the context of the 1964 order. Para 3 of the 1964 order requires that a proceeding must be served with the main ground on which he or she is alleged to be a foreigner. The expression main grounds is of significance. It cannot be reduced to a bare assertion that a person is suspected to be a foreigner. The proceeding must know, at least in substance, the basis on which the allegation is founded. Only then can the proceeding meaningfully answer the reference and discharge the burden cast upon him or her. The proceeding prescribed under paragraph 3 of the 1964 order also shows that the proceeding before the tribunal is not an administrative formality. The proceeding has to be given an opportunity to file a reply, produce evidence, and be heard. The concerned superintendent of police may also produce evidence. The tribunal may hear such person as it considers necessary. After the case is heard, the tribunal is required to submit its option. The final order must contain a concise statement of facts and conclusion. These requirements are inconsistent with any notion that the tribunal may simply affirm the reference upon non-appearance of the proceeding. Even in a case where the proceeding fails to appear despite service, the tribunal continues to act as a quasi-judicial forum. It must satisfy itself that notice was duly served in accordance with law. It must examine whether the main grounds were made available to the proceeding. It must consider the evidence produced by the state. It must assess whether the material placed before it is capable of supporting the conclusion that the proceeding is a foreigner. It must record reasons, even if briefly. An ex parte proceeding may dispense with the participation of the absent party, but it does not dispense with the objective consideration and meaningful adjudication by the tribunal. The statutory scheme, therefore, has two complementary features. The first is that the proceeding carries the burden of proving that he or she is not a foreigner. The second is that the tribunal must ensure a fair procedure, meaningful notice, consideration of material, and a reasoned opinion. These features are not in conflict. They operate together. The burden under Section 9 of the 1946 Act arises and is discharged within the procedural safeguards of paragraph 3 of the 1964 order. The above understanding is fortified by the judgment of this court in Muhammad Rahim Ali at Abdur Rahim versus State of Assam and others. In that case, the court examined the operation of Section 9 of the 1946 Act and paragraph 3 of the 1964 order in the context of a declaration made by a foreigners tribunal. The court explained that the burden under Section 9 is not to be understood as permitting the authorities to proceed on a bare allegation or an unsupported suspicion. The authority must possess some material basis for initiating the proceeding, and the proceeding must be informed of the substance of the case which he or she is required to meet. The decision of Muhammad Rahim Ali is important for another reason. This court drew a clear distinction between the mere allegation that a person is a foreigner and the main ground contemplated under paragraph 3.1 of the 1964 order. The expression main ground requires something more than a formal accusation. It requires disclosure of the essential basis on which the allegation is founded, so that the proceeding is not left to answer an undefined suspicion. Without such disclosure, the opportunity to file a representation and produce evidence would be more illusory than real. The court in Muhammad Rahim Ali also clarified that Section 9 does not exclude the principle of natural justice. The statutory burden placed upon the proceeding operates only after the proceeding is lawfully initiated and after the proceeding is placed in a position to understand the case against him or her. The burden cannot be shifted in a vacuum. A person cannot be expected to prove the negative without being told with reasonable clarity the material basis on which he or she is alleged to be a foreigner. The consequence of a declaration by a foreigners tribunal was also discussed by this court, as it was held that such a declaration is not a routine civil consequence. It may lead to detention, deportation, separation from family and community, and in a given case, even the possibility of statelessness. The court therefore emphasized that a process by which such a declaration is made must satisfy the minimum requirements of fairness and must rest upon material capable of supporting the conclusion. The requirement also have a constitutional foundation. Article 14 and 21 of the Constitution of India, 14 and 21 has been read out to your lordship. Then it is necessary to lay emphasis on the language of both this article 14 of the Constitution. 14 of the Constitution uses the expression any person. Article 21 of the Constitution uses the expression no person. Neither provision is confined to citizens. The protection of equality before law, equal protection of law, life and personal liberty is therefore available to every person within the territory of India. A person proceeded against before a foreigners tribunal may ultimately fail to establish Indian citizenship, but the process by which such determination is made must still satisfy the constitutional requirement of fairness, reasonableness, and non-arbitrariness. The court has consistently recognized that even a foreigner is entitled to the protection of life and personal liberty under Article 21 of the Constitution. In Louis D. Wade versus Union of India, this court held that the fundamental rights of a foreigner is available under Article 21 of the Constitution for life and liberty, although the right to reside and settle in India under Article 19(1)(e) of the Constitution is confined to citizens. This distinction is important in the present case. The state may regulate the entry, stay, and removal of foreigners in accordance with law, but the person concerned is not placed outside the protection of fair procedure. Your Lordship, till this, Your Lordship, the court has been loud and clear, Your Lordship, in Rahim Ali, and even in this case, Your Lordship, it has been clearly stated, Your Lordship, there has to be an inquiry, Your Lordship. The foundation of a foreigner's case relies on an inquiry and the materials available that has been collected against the procedure by the authorities concerned, Your Lordship. And this court, in those judgments, went on to say that those materials has to be supplied to the procedure, Your Lordship, so that they can have a clear understanding of the case and the reason of suspicion behind it. In this case, Your Lordship, there is no materials, Your Lordship. The inquiry or the materials that has been collected is in my favor, Your Lordship. Even in cases which goes against my favor, Your Lordship, there has to be certain materials, there has to be a fair inquiry, and those materials are required to be supplied to me, Your Lordship. But in this case, Your Lordship, what is available, Your Lordship, from the inquiry report, I don't know, Your Lordship, if there is other materials in the record, Your Lordship. But going by the inquiry report here, Your Lordship, there is no materials against me for my name to be referred to the foreigners tribunal, Your Lordship. Your Lordship, these are the.
So your contention is that not just in terms of this judgment, not just allegation of being a foreign national,
Yes.
but why the state.
Yes,
is
Your
a
Lordship.
foreign
It also suffice, Your
national.
Lordship.
And once those grounds are given to the person proceeding,
Yes, Your Lordship.
that these are the reasons why state considers you to be a foreigner. And after perusing those grounds,
Your
the
Lordship.
proceeding will adduce his or her evidence.
Yes, Your Lordship. Your Lordship, that has also been, Your Lordship, clearly stated in a judgment of this honorable court in Hyder Ali, Your Lordship, where this court went on to say that written statement referred to in foreigners tribunal case cannot be constituted with the written statement under Order 8, Your Lordship. The very reason because we don't have a just a moment, Your Lordship. Your Lordship, that is my humble submission, Your Lordship, that Your Lordship, if Your Lordship, once the names gets referred to the Foreigners Tribunal, Your Lordship, I have got limited scope, Your Lordship.
We did to disturb you, that you see this, the case we have cited,
Your Lordship.
we have dealt with a ERO reference. And ERO reference is always generated under the Representative of the People's Act 1950. And under that act, all references must be sent and the inquiry by the SP is never made.
Lordship.
It's only a doubt created and earlier IMDT was the appropriate authority. And we have answered this in many cases, not one. This answer we have given in not one case. I think I have on the bench where I am there. I think we have answered it more than 20 times. The same thing. Nowhere in these cases, even in the recent judgment of that Savitri you are referring to, it does not deal with the paragraph 26 of the Sovereign Solomon. You see, assuming we are just giving a what do you call hypothetical situation. We ask A, is he a foreigner? You expect him to say that yes, I am a foreigner?
Unlike
Unlikely.
anywhere in the world, no.
Correct.
No.
If you so therefore the para 26 deals with that, and that is the wisdom not by this court. This wisdom was exercised by the Supreme Court of a larger bench of 3 judges. So that has been dealt with. And now the second part of limb of your argument, that there should be materials before the persons. Those were all cases which were investigated under the reference made under the Foreigners Act, where the suspect was interrogated by the LU under the Supreme of Police. So that doesn't deal with all these issues which are raised here. But you are passionately making a submission we do not want to interfere with. Your entire argument is of no consequence under the facts of this case.
Your Lordship, my humble submission in this regarding Your Lordship.
ERO reference.
Your Lordship, the Honorable Apex Court has made this,
It doesn't refer to a ERO. You see, we must understand the law under the, how is a judgment read? A judgment is an authority on the facts on which it is decided.
Yes.
Look at this, Savitri, none of the cases referred are ERO reference. You don't expect the reference by the Election Commission to be reinvestigated by the police as if the Election Commission is nothing in the eye of law. It merely says that it has to be referred. Yesterday's papers carry that news that the Election Commission can doubt a citizenship, but it will not adjudicate on citizenship. So that's again the Supreme Court judgment, very clear on the point. It's a doubt created and sent to the adjudicating authority. Adjudicating authority finds that he is not there. So that entire satisfaction is not even required. In your case, I think he is an agriculture extension officer, who is the investigator, who is the LBO. Do you expect the what you call the agriculture extension officer to be competent to act like a policeman to make inquiry? No.
Your Lordship,
He'll at best know how a particular chemical can be used for a better agricultural output.
No, has been deputed for that. When the ERO form is filled up during this verification,
Your Lordship,
this column says that we have migrated to Assam. right?
Yes.
This particular column. And the answer is, no. So that is, that no or yes is on the basis of any inquiry or on the basis of whatever answer is given by the person concerned.
Your Lordship, if an reference is made, Your Lordship, something has to be there against that person, Your Lordship.
That's why you say you're not even read the conspectus of the election laws. A doubt has to be generated. It will only have a doubt
Your
that
Lordship.
I doubt this person to be a bona fide voter, and it is sent. There is no material. It's only a doubt. And that we have dealt with in more than 20 answers we have given.
Effective by the Ghosh Mohammed, that case has not been considered by the Honorable Apex Court in this case.
No, not considered.
Yes, the 1961 SCC online, SC2,
Which one?
and 1961 Ghosh Mohammed. AIR, my lord, 1961 SC 1526. That's a 5-bench judgment, my lord, where it is clearly, yes, constitutional bench.
Postmortem.
Ghosh Mohammed. AIR 1961 SC 1526, my lord. SCC online, it is 1961 SCC online SC2.
Post spelling?
My lord, Union of India versus Ghosh Mohammed. GAUS.
USC.
GAUS. They are in para 2. This is the situation, my lord. This is exactly against this present judgment with all respect to the Honorable Apex Court, my lord. The present judgment has gone exactly against this judgment, my lord. Because in para 2 it is said, my lord, the High Court observed that why the order was set aside. There must be a prima facie material on the basis of which the authority can proceed to pass an order under Section 32C of the Foreigners Act 1946. That is the observation of the Honorable High Court. No doubt, if there exists such a material and an order is made which is on the face of the valid order, then the court cannot go into the question whether or not a particular person is a foreigner or, in other words, not a citizen of this country, because according to Section 9 of the Citizenship Act 1955, the question is to be decided by the prescribed authority under the Citizenship Rule 1956. That authority is the central government. The High Court then examine the material before it and held that in present case there was no material at all on the basis of which the proper authority could proceed issue an order under Section 32C of the Foreigners Act 1946. This is the observation of the High Court, which is now, my lord, in the present case.
The question he has raised, the principle.
Lordship, this order.
Irrespective of the direction from which the question has come.
Yes.
SPO, SP border inquiry or ERO, as a proceeding, as a
Yes.
proceeding, would definitely, like to know that why I am being, why the suspicion is there?
Yes,
Why?
materials that
Because I don't have documents.
the material, according to the material has to be there. Normally, the Honorable Apex Court, against this observation of the High Court, what he has said, it was contended on behalf of the Union of India, the section, my lord, that was under Section 9 of the Citizenship Act 1955, had no application in this case. My lord, we have to differentiate Section 9 of the, my lord, the Citizenship Act and Foreigners Act, Section 9 of the Foreigners Act. We are under Section 9 of the Foreigners Act, my lord. So our cases deals under Section 9 of the Foreigners Act. We think that the contention is correct. The section deals with the termination of citizenship of a citizen of India in certain circumstances. It is not the union case. It is not the union case, nor that of the respondent that later citizenship came to an end for any other reason, any of the reasons mentioned in the section. The reference to that section by the High Court of the decision of this case, was therefore not opposite. The section had no application to the facts of the case. So Section 9 of the Citizenship is with regard to termination of the citizenship. Now, my lord, para 4 it is said. Section 2A of the Foreigners Act defines foreigner as a person who is not a citizen of India. Subsection 1 of the Section 3 of the Act gives power to the central government by order to provide for presence of a continued presence of foreigner, provide for the
683.
yes.
subsection 2 of the section 3 gives express power to government pass orders. Now, in para 5, your lordship may kindly see.
Para 5 of,
Para 5 of this Ghosh Mohammed, madam.
oh, Ghosh Mohammed.
Yes.
Just wait. Just put that on.
1961 SCC online, SC2, madam.
Yeah, 1961,
AI 1961 SC 1526, madam.
1536.
1526.
You see, Supreme Court has relied on this Louis D. Reid.
Yes.
Have you read that judgment?
No.
It's a very interesting judgment. In this case, the person was a missionary and he had come for a limited period of time in this country and stayed for 10 years. And then he claimed that he should be treated as a citizen of India. And here, the Supreme Court relies on the judgment of what do you call? But Nuremberg, what is that Nuremberg?
Yes.
I'll tell you, it's some Nuremberg versus state of West Bengal. There it relied and says that the state has unlimited power of expulsion of a foreigner. You see, except for the state of Assam, nowhere in the country there is a foreigners tribunal. And therefore, the executives in other part of the country, they are empowered to send back a foreign to its country of origin. Now, therefore, read it. That Hans Muller of Nuremberg, that is the case on which it is relied. And this has been too elaborately dealt with in that Sarvanan Sonwar. So except for the fundamental right of life and liberty, there is no other fundamental right to move or to reside anywhere freely. That was again decided in the case of Khudiram Chakma by the Supreme Court.
Yes.
So therefore, a person merely by his dint of stay, and in that Hans Müller of Nuremberg, it does not refer to the giving of the materials to the person to claim to be a citizen of India, because he was admittedly a foreign national. Now, this is what is this Ghosh Mohammed.
Yes.
We'll take a short break and come back.
Yes. In this judgment, your lordship may consider the para 2 minor.
Which judgment?
In the Louis D. With this Ghosh Mohammed minor. Para to the High Court state minor, the High Court observed that there must be prima facie material on the basis of which the authority can proceed to pass an order under section 3(2)(c) of the Foreigners Act 1946. By the Foreigners Act under section 3(2)(c), my lord, one can be expelled from India, being foreigner. Now, this has been, after considering para 2, 3, 4, 5, your lordship may kindly see para 6, ma'am. Here in this judgment, my lord, the
No. Yes.
here in the judgment, your lordship, the Honorable Apex Court has distinguished made the distinction between section 9 of the Citizenship Act and Foreigners Act, section 8 of the Foreigners Act. under section 9, my lord, of the Foreigners, section 9 of the Citizenship Act and Foreigners Act. Now of the distinction in para 6, my lord, it has distinguished para 9 of the, section 9 of the Foreigners Act also. Now section 9 of the Foreigners Act has been, my lord, under para 6, section 9 of the Foreigners Act has been quoted. Now, in the thereafter it is said, my lord, it is quite clear that this section applies to the present case and honors of showing that he is not a foreigner was upon respondent. The High Court entirely overlooked the provision of this section and misdirected itself as to the question that arose for decision. The High Court said, my lord, that's why I showed, my lord, in para 4, para 2, what High Court observed, that is there, my lord. High Court said there must be prima facie material on the basis of which the authority can proceed and pass an order under section 3(2)(c). Now the Honorable Apex Court in this judgment has clearly said, no, the High Court is misdirected, they have misconceived matter. The High Court entirely overlooked the provision of this section and misdirected itself as to the question that arose for decision. It does not seem to have realized the burden of proving that he was not a foreigner, was on the respondent, and appears to have placed the burden on union. This was wholly wrong approach to this question. So this is the settled position by the Honorable Apex Court long back in 1961 itself. It is a full bench decision. Neither in the Rohimali nor in this matter Sabitri Day.
The original exposition.
Original ex. This was not.
Section 9.
This is exactly matter the Sabitri Day matter para 15. What it says, matter exactly what the High Court says in this judgment. Because in para 15, the Honorable Apex Court.
Constitution. Constitution.
Constitution bench. This is a constitution bench judgment. This is a division bench judgment of.
Yes.
Para 15, my lord, middle part, I'm saying para 15 and para 15 of the Sabitri, my lord, that Sabitri Day judgment. What it says, my lord, it is exactly against this judgment, my lord, the present judgment of this Apex. Even in case where the proceeding fails to para 15, my lord, even in case where the proceeding fails to appear despite service, the tribunal continues to act as a quasi-judicial forum. It must satisfy itself that notice was duly served on a court.
Yes.
Para 15, it says, my lord, I'm not in the first part, second part, my lord. It must examine whether the main grounds were made available to the proceeding. It must consider the evidence produced by the state. My lord. It must assess whether the material placed before it is capable of supporting the conclusion that the proceeding is a foreigner. It must record reason even if briefly. So, prima facie materials as per this my lord judgment, prima facie material has to be there. As per this para 15. Before issuing notice. Before issuing notice.
Before the issuing notice and before
Before
the
declaring
proceeding is asked to discharge that.
discharge the parties. So this is exactly against the judgment of the Ghose Mohammed. My lord, Ghose Mohammed has clearly said, my lord, no prima facie material is necessary in case of foreigners, my lord. But it says if it is under section 9 of the, my lord, Citizenship Act, then it will be different. But it is under section 9 of the Foreigners Act. Section 9, my lord, he is a citizen of India. Somehow, if sometime it is necessary to terminate his citizenship under section 9 of the Citizenship Act, then, my lord, prima facie there must be material. That is what the Ghose Mohammed has said.
The thing is that, looking at it another way, this only, staying
Yes.
with section 9 only and this interpretation.
Yes.
That when any question arises with regard to, whether as to person, whether a person is or is not a citizen, whether, when any question arises, when that arising of the question is based on what material?
That is the doubt, my lord. That can be, that is no document. In fact,
Submitted, that
in fact,
ABC, anybody cannot be just say.
no, in fact, in the present case, there is inquiry.
Person can produce
Yes.
the document.
Yes.
Somebody has a now passport. I don't know what. I mean, the person will show if somebody.
In fact, in the present case, my lord, the inquiry was done. Inquiry reveals he did not disclose, he did not submit any documents before the LVO.
Then that is the premise.
That is the prima facie evidence. But in fact, my lord, the Foreigners Act, if we see, my lord, the language of the Foreigners Act,
Is there in that Ghose Mohammed?
yes, it is there. My lord, the Foreigners Tribunal, my lord, your lordship makes, I'd like to provide my lord, read the two provisions, my lord. The 1964 order, Foreigners Tribunal Order 1964, section 2, my lord, order 2, my lord, Constitution of Tribunal. The language your lordship may see. The Constitution of Tribunals, my lord. The central government or the state government of the Union Territory administration or the district collector of the district magistrate may, by order, refer the question as to whether a person is or is not a foreigner within the meaning of the Foreigners Act 1946 to a tribunal to be constituted for the purpose for its opinion. So there is no question, or there is no burden given upon the state to make inquiry before referring this. And the provision is clear, man. The central government or the state government or the union, there is no burden given on any authority, either to the central government or to the state authority or to the district collector or district magistrate to make any inquiry, in fact, prior to making the reference. Refer the question.
Is it?
May by order, it is clear, man. Now, as I have read out, I have said, Madam, Ghosh Mohammed has distinguished the Citizenship Act and Foreigners Act. What the Section 9 of the Citizenship Act says, Madam, it is termination of citizenship. If the Section 9, may I read this Section 9 of the Citizenship Act, Madam? Termination of any citizen of India who by naturalization, registration, or otherwise voluntarily acquires or has at any time between 26 January 1950 and commencement of this act voluntarily acquired the citizenship of another country till upon such acquisition or as the case may be, such commencement cases to be citizen of India, provided that nothing in this subsection shall apply to the citizen of India who during any war or so and so engage voluntarily citizenship of another country until the central government otherwise directs. And then if any question arises as to whether or when or how citizen of India has acquired the citizenship of another country, it shall be determined by such authority in such manner and having regard to such rules, evidence as may be prescribed in this behalf. So under this Section 9 of the Citizenship Act, Madam, it is the duty of the government and it is the burden of the government. It is the burden of the government if the union territory want to terminate a person's citizenship, then this Section 9 of the Citizenship Act follow. In that case, burden may lie, prima facie burden may lie to the central government. But we are in the Foreigners Act, Madam. The provision in Foreigners Act and the Citizenship Act is totally different. In vice versa, because it is vice versa, because under Section 9 of the Foreigners Act, the burden is on the proceeding. So Ghosh Mohammed has distinguished these things. That's why it says, Madam, under the Foreigners Act, Section 9, prima facie burden is not, there is no prima facie burden to the state. And if it is, my lord, as your lordship knows, my lord, under the, in fact, the Sobananda Sunwal, my lord, Sobananda Sunwal, para 22. Sobananda Sunwal in para 22, the Ghosh Mohammed has been referred. 2005 5 SPC 663. In para 22, it is referred that it has been considered. And that's why the burden was given upon the mother, the proceeding. 2005 5 SPC 665. Supreme Court, Madam, para 22. It is said. In para 22, it is said, may I read, Madam, slowly I read. Para 22. This act confers wide-ranging power to deal with all foreigners. This act means the Foreigners Act, foreigners, or while respect of any particular foreigner or any prescribed classes or description of foreigner for prohibiting, regulating, or restricting their on his or his entry into India or their presence or continued presence, including their arrest, detention, and confinement. This is what the purpose of Foreigner Act. This is what is the purpose of Foreigners Act is, madam. This is what the purpose of Foreigners Act, madam. The Foreigners Act, under the Foreigners Act, these are the minor functions. But under the Citizenship Act, Section 9, it is termination of citizenship. Prohibiting, regulating, or restricting their or his entry into India or their presence on or continued presence, including their arrest, detention, and confinement. The most important provision of Section 9 which casts the burden on of proving that a person is not a foreigner or is not a foreigner of such particular classes or description, as the case may be, shall lie upon the person. Therefore, when an order made under Foreigners Act, it is challenged and question arises when the person against whom the order has been made is a foreigner or not. The burden of proving that he is not a foreigner is such a person is made to a foreigner or not. The burden of proving that he is not a foreigner is upon such a person. The Union of India versus Ghosh Mohammed, the Chief Commissioner of Delhi served an order of Ghosh Mohammed to leave India within 3 days as he was a Pakistani national. He challenged the order before the High Court, which was set aside the order by the observing that there must be prima facie material on the basis of which the authority can proceed to pass an order under section 3(2)(c) of the Foreigners Act 1946. In appeal, the Constitution has reversed the judgment of the Honorable High Court, holding that the onus of showing that he is not a foreigner was upon the respondent. So this is exactly the situation, madam. This is, yes. Yes, ma'am. Yes.
Along with the meaning.
Yes. Yes, ma'am. That is always there, madam. The notice is given. In fact, this honorable court has said the ground may be consist in the notice. Ground doesn't mean, madam, ground does not mean, madam, each and every document has to be given to the petitioner. Generally grounds are mentioned that you have been doubted to be citizen of India. So you are here, but the notice, if your lordship may kindly see, in fact, this honorable court has settled that notice, in fact, the ground may contain it on notice itself. Yes, ma'am. Citizen of the notice. So, my lord, my learned friend's argument that, my lord, there must be prima facie materials before grounds before giving notice to him. The tribunal itself must satisfy. That is against the melody. That is not correct. The Ghosh Mohammed has clearly said prima facie material is not necessary. In fact, section order 2 of the Foreigners Tribunal order also says the state government and central government has the absolute power to make reference against any person. So, and thirdly, my lord, because this is a special category of cases in state of Assam, the history of this part of the India with regard to this Citizenship Act and citizenship, my lord, because the IMDT, the provisions of IMDT were some extent there, where it was provided that the state authorities should bring materials to the tribunal, to the IMDT tribunal, before issuing notice or before taking any cognizance. And that view was that IMDT was set aside by the Honorable Apex Court in Shokananda Sunal for that reason also, my lord. That is that, I read, my lord, again, para 40, 41, 42. If I bring an allegation, my lord, suppose I give a notice, but the state authority, my lord, give an allegation that no, he did not enter in my lord, entered in India, or he entered in India prior to after 1971 from East Pakistan. And if I give the specific ground, my lord, tomorrow he will come, my lord, only on that ground only, challenging only on that ground. So we have offered them, my lord, we have offered them whatever documents you have, you can produce before the tribunal. If it is not, my lord, they are no way prejudiced by not giving, my lord, the documents, what is there in the, my lord, foreigner's tribunal, or what is seized, or what is available there in the, my lord, the tribunal, in the custody of the tribunal. They have ample opportunity, my lord, they have been given enough opportunities. Whatever documents they can bring it. Not a specific ground, my lord, not only a single ground, my lord. If they can, what prejudice will, my lord, cause to him or her by not giving those documents at the time of evidence, my lord. He has produced all the documents before the tribunal. After considering all his documents, all her documents only, the tribunal has passed the opinion, my lord. Now he is going back. No, I should be served with the, my lord, grounds and documents. Then only I can prove my case. What documents are there, my lord? He has submitted whatever documents he has. If she can, my lord, prove on the basis of these documents that she is a citizen of India, then she will be definitely, my lord, allowed. So my submission is no prejudice is caused to him or her, even if, my lord, the details of these documents are not served to him. And in grounds, my lord, the grounds, elaborately, the grounds are always there in the notice, my lord. If your lordship can see the notice, my lord, notice it is there. Other than marriage, my lord, it is sin. There is no case at all, my lord. Married, my learned friend will submit, my lord, because he was dealing with it.
Merit lordship has gone into the Lordship, in these matters, teamwork is required, Lordship. Yes, Lordship. Lordship, the date of birth of the petitioner is 1961. As on 2019, I just calculated 66 voters list and 85, the father and mother's name is there. 85, there is a shifting, Lordship. And 2015, the mother's name, and 18. I may draw Lordship's attention to 1985 voters list, Lordship. It is at page 1985 is at page 34, Lordship. The mothers, there is a variation of 19 years in the age of the mother, and there is a change of village also. Shifting is there, which has not been explained, and mother's age from Rupjan, Lordship, at page 66 voters in Lordship. I may just 66 voters list is Rupjan and 85 voters list is Rupjan. The names change. There's a variation of 19 years, Lordship. And there is no explanation as to why there is no other voter list in between 66 and 1985. 66 voters list is at page 29, Lordship. Village is Silpukuri. Mother Rup Jan. She is 29 years of age. And if then 85, Lordship, 70. The in between voters list is not there. Then there's a direct jump to 1985. And if the petitioner links herself to the projected parents' lordship, her name ought to have appeared in the year 1981 at the age of 20 years. She got married only when she was 29 years in the year 1990, Lordship. That is her statement in her deposition, Lordship, at page 1981, Lordship, along with her parents, brothers, and all, Lordship. Because she was born in 61, she got married at the age of 29 years. Her right to vote comes first in the year 1981. 21 years. And I'm getting all these facts from the documents here, Lordship, in her own statement at page 59. 59, Lordship. She has written, in her WS, she has not stated when her father died, when she got married. Nowhere has it been stated. But in her cross, Lordship, in her cross at page 72, Lordship. May I draw Lordship attention to page 72? In the cross for the state, I was born in the year 1961 at Sulpukhuri, Nagaon. My father was late Syed Ali, and he died in the year 2004 at Ali Singha, Morigaon. My father was born at Silpukuri, Nagaon. My grandfather was late so and so. I got married in the year 1990. So if she is born in 1961 and she gets married in 1990, she's 29 years of age. My friend had submitted that she got married when she was 13 or 14 before she attained majority. And all along, Lordship, the inquiry report and all are her name is attached to her husband, not to her father or her mother. And I'm not an income tax payer, but she has a PAN card, Lordship. No coroner's case is pending or initiated against any members of my paternal family or husband's family. So the most important information is in her cross, which was not stated in the WS or in her evidence, Lordship. And then the mother's name, Lordship, Rup Jan to Rup Jan. It keeps changing. Now, whether the Rup Jan of 66 and Rup Jan of 85 and subsequent voters list is one and the same, that is another question, because she has 3 aliases in her name. The age is there, the shifting is there. After 85, there's another shifting in 2015. 2015 also there's a shifting, Lordship, and 2018 is same. But if her brother's names could have appeared, her name also ought to have been there because she married only when she was 29. And relying on the Gaubura certificate, Lordship. It goes because the state emblem is there, which is against the rules. And the Gaubura's deposition also, Lordship. Shifting of the village, Lordship. I found it in the voters list. It is not there in the written statement. 66 is another village, 85 is another village. And 66, 32, 85 and 2015 is Ali Singha, 36 at page 36. Lordship, I'm just coming. 36. 85 is Lordship, village is Kalpia, Behguri. And then 2015, the main village is Ali Singha, where they state that they have been residing there. That is only in the year 2015, but in the year 66, they were in Silpukuri in a different village, Lordship. That was in Nagaon, I think. That was in Nagaon, and now they are in Morigaon. The districts have completely changed. 66 and 85 is Nagaon, and now it is Morigaon. 2015 is Morigaon. And here, the mother's name appears with her 3 sons, 2 sons. But the daughter's name is not there. And 85, the voters list, Lordship. Mother's age is 37, whereas it ought to have been 48. Then after that, the continuity is there with the sons. And the daughter's name from Ajita to Ajifa and Afisa. Maybe to connect the documents, her aliases has increased, Lordship. And the Gaubura states in the year 2016, Afiza Khatun got married to Majibur Rahman, son of Habibur Rahman of village so-and-so, and this is true. But Lordship, this Gaubura certificate will not sustain because it has a state emblem in it at page 41, annexure 9. And in the translation, there is a mistake, Lordship. Gaubura certificate, one date is 2016 and one date is 2015, this seal one. Not a tax pay, but the PAN card is there, Lordship, at page 42, not legible to read under what name it is. Since there are 3 names, Lordship, it's so difficult to read. And the voter ID is, Lordship, in the name of Hafiz CHI. So because there are 3 different documents with 3 different names, so the aliases has increased. None, not a single document to link her with her projected parents or her brothers. Her mom had come, but the brothers did not come to adjudicate, and there's no name. And since she did not produce any document before the PRO, Lordship, so their form will state whatever has been given, what address she has given. Here she has stated her name as Ajifa Khatun, but subsequently it kept on changing along with the documents. Spellings changed, her name changed, Lordship. And husband's name is Majibur, that is consistent all through. And since no document was submitted, so it has not produced any documents nil. If any document had been submitted, it would have been written there. And whether migrated to Assam, like Lordship knows, nobody will say, yes, I am a foreigner and I have come to Assam So that is not there.
There is a document of NRC,
Yes, that is at page 20, paragraph 20,
which
page
is again village Amguri Sapuri at district Sonitpur.
2. Yes.
Your Lordship. Yes, Your Lordship, he got married.
He got married in Nagaon, Lordship, not in Sonitpur,
Your Lordship, maybe. No,
This is the court village.
Fourth village.
in her affidavit also, she states that she is from Amguri. She is the resident of Amguri Sapuri PS Thalabala.
That is Nagaon.
District Sonitpur.
And now actually she belongs to this district, Naga or Sonitpur.
Now she is residing from.
Whichever district she could find the document, she connected herself that side. Is this okay? She has documents of everyone, voter list of everyone except herself with her parents' list. Her only document is the Gauhati certificate, which does not stand, Lordship.
Lordship, with due respect to the submission made by my senior Lordship, but they had said that she belongs to every district, Your Lordship, but she perhaps doesn't know, or perhaps she has that the district of Nagaon got bifurcated in the year 84, 85 or thereafter, and it has become Nagaon and Morigaon, Your Lordship. So the erstwhile, Your Lordship, Nagaon, that Lahorigarh portion now falls in Morigaon. The Mayang portion now falls in Morigaon. It was in Nagaon before 85 or the year before. Your Lordship.
Common district.
Yes, Your Lordship. It was a common district then. And Your Lordship, there are thousands of persons, Your Lordship. Your Lordship, the things has to be dealt with the practical scenario, Your Lordship. There are thousands of persons belonging from Morigaon district who resides in Sonitpur. They just, when they get affected by erosion, they cross the river and get settled on the other side. So these are the one of the things, Your Lordship. And going back, Your Lordship, yes, Your Lordship, there are anomalies with regard to the age, Your Lordship. Even the age of the mother with her son, the difference has been shown 7 years in the voter list of 1985, Your Lordship, which definitely cannot be true, Your Lordship. And Your Lordship, this cannot be attributed to cannot be attributed as a fault of the petitioner, Your Lordship. And with regard to, Your Lordship, Gauhati certificate, Your Lordship, there may be an emblem, Your Lordship, which the Gauhati have stated, but Your Lordship, the contents of the certificate as well as the depositions, Your Lordship, that cannot be invalidated, Your Lordship. And if I remember, Your Lordship, I am not sure now, Your Lordship, there was also an order, if possible, I will, Your Lordship, place that order, Your Lordship. And with regard to the earlier contention, Your Lordship, even in Sarvananda Sunwal, Your Lordship has rightly pointed out in para 23, Your Lordship, it was stated that that a person has to be provided with the main grounds, Your Lordship.
No, you have read the
Again-
part of the statement.
Yes.
the statement was that even severance onward did not deal with the issue of ERO.
Yes, your lordship.
Doesn't deal with ERO at all, severance onward. It was not a case of dealing with the references made by the ERO.
Yes, your lordship. Now, again, in the same order, your lordship, in para 35, subpara 10, your lordship, it has been stated, your lordship, on receipt of a reference under subsection 1 of section 8 or subsection 1 of section 88, the tribunal shall serve upon on the person named in such a reference a notice accompanied by a copy of such reference, calling upon him to make with so and so. Your lordship, now, your lordship, even your lordship, I have not been handed over with the inquiry report, your lordship. As simple a notice goes, your lordship, that is a cyclo-style notice, your lordship. Something gets mentioned in a blank, and your lordship, I am being expected of to contest the case. Your lordship, whatever your lordship argument that has been made by my learned friends from the opposite side, your lordship, those arguments ought to have been made before the apex court, your lordship. Your lordship, that unfortunately has not been made, your lordship. And your lordship, this is an order of the apex court, your lordship, which we are dealing here, your lordship. So I'll leave it to your lordship, your lordship. Your lordship may decide this, your lordship. Whether your lordship, a person, because your lordship, in Ghost Muhammad and other cases, your lordship will find in other parts of Assam, your lordship, a foreigner gets caught. He, in the very instant, almost he admittedly says that I have been living as a foreigner, my visa has expired or have come. But in case of Assam, your lordship, 99% of the proceeding, your lordship, they produce documents from 1951, even from the pre-British era. What gets difficult, your lordship? The linkage. In most cases, the linkage comes into place, your lordship. Why we are, your lordship, putting emphasis on the initial burden of proof? Because once the, your lordship, reference gets referred to the foreigners tribunal, your lordship, he has to deal with it in accordance with law. And thereafter, your lordship, things get tough, your lordship. Because, your lordship, even in the High Court, your lordship, this is a certiorari bench, your lordship. So the initial burden of proof, if not exercised, your lordship, diligently, your lordship, then, your lordship, the petitioners doesn't have much to, your lordship, deal with, your lordship.
You did not allow me to finish. खत्म कोई मत बोल सर्टिफिकेट ऐसा दे तुम्हारा Lordship, I had just one last thing to point out. Gauhati
There is an order to be delivered, but there is a link failure between this court and the ISOL bench. So I'm passing the order singly. The repetition is dismissed.
Item number 19 and 20, that habeas corpus matter.
Oh, yes.
Whether it will reach or not, I don't know.
No, we'll take it up. We have already issued a direction that we will take it up.
The direction you also issued to come today.
Yes, yes. We'll take it up.
Much.
In a short while, we'll call it.
May I please, Your Worship? I'm sorry to mention item number 29. Let the matter come up next week, matters.
It's a 2019 matter. You'll have to
Yes.
wait for some time till we look at the record. Because adjourning of 2019, 2021 matters is very difficult. Just wait for some time.
Maybe little Lordship, item number 9. My lord, I want 2 days time. I am not prepared as my father has died. I am not mentally prepared to do. My father already died, recently died. I am not complete my preparation. 9. Weeks. Only.
17.
It is your Lordship. Lordship, item 48, I made a mention for listing. This is a new matter, Lordship. Contested matter and June, impugned order is dated June, Lordship. So may I pray to take up this matter? Otherwise, it may not reach, Lordship, if taking up item. Lordship. 48, supply, Lordship, listed by order, Lordship. Lordship.
Item number 15, kindly fix the matter at 29 now.
For motion, item 6.
So this is a contested matter. The impugn order is at page 57.
August.
Obliged.
Item 7 for motion.
Lordship, matter may be possible for the time being. Must
24 August. Item 8.
May be legal.
Admission.
Manche, there is an imprimatur may continue. Public food. Public.
Item 10.
May please, your lordship. Also, here the matter is again listed in the motion column, but I find lordship notice has not been issued. And also, lordship, I want to just go through the records once, lordship. before going to the hearing. Also, can I go through the records?
Eleven.
Lords. Lordship.
The opinion, judgment and page.
Says Lordship. 29. Here, DW2 has not been considered, Your Lordship. DW2, evidence of DW2 has not been. DW2 is the paternal uncle of the petitioner, Your Lordship. And he shares the voter list along with his petitioner's father. Only issue is the name, discrepancy of name of petitioner's father here. In 1966 and 70, petitioner's father's name has some discrepancy. Your Lordship. And DW2, evidence of DW2 is vital, Your Lordship. Since the DW2 shares voter list of 1970
With the petition.
with the petitioner's father. When evidence of DW2 has not been discussed, Your Lordship, not rejected and not considered. Lordship. 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 Page 30 only, your Lordship. Lordship. Only here is Lordship, it is stated but not considered. And said that not considered. Lordship. 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 In the voter list, his name is there. Lordship, yes. Lordship, name of the uncle is not there, Lordship. Is not stated, yes, Lordship. It was not stated. Lordship. It is not stated paper. Yes. Hello, Lordship.
Item 12.
Yes, Lordship. Lordship, in this matter, my lord, Mr. Council, Mr. Rohit, my lord, due to his personal difficulty, he could not come to the court, my lord.
It is Krishna. Yes.
Item 13.
My pleasure, Your Worship. My lord, the conducting counsel is H. Ahmed, my lord. She was here indeed, my lord. She left due to some personal difficulties, my lord.
My lord.
Yes. Last page. Yes, sir. Yes.
Yes.
Yes. It should have been by the when the names were entered. Thank you. But yeah. In fact, in evidence also, my lord, they have not stated with the documents at page 62, para 6, the evidence is given with regard to that exhibit number 3, my. There is no date when entered, and who are the persons in the Khatian folder, my lord? Same date, exclusive date.
My lord, in page 19, it is there, my lord, in page 19 of the petition. Yes, ma'am. In vernacular. 8 to 1962, my lord. Bottom.
Yes, this way not taken.
Zero five.
Obliging.
Yes.
Item 14.
May I please? In opinion, lordship will find at page 59, opinion dated 5/9/2019. Your lordship comes to page 62 of the opinion. Next, 59, it starts from 59. If your lordship comes to page 62, the proceeding exhibited, lordship got it. Page 62. Exhibit 3. Exhibit K, Lordship, at page 62. K. The proceeding exhibited sealed it. Yes. But it was verified by the yes. Yes, because the erosion lordship. That in the evidence also it has been stated lordship that due to erosion we have shifted. Yes. Here lordship, father as DW2 has filed his evidence. Father, then grandmother as DW3 has filed her evidence. Husband also filed his evidence. Kaji was cross-examined as DW5. Secretary of the Gram Panchayat was cross-examined as DW6. Headmaster was also cross-examined as DW6 or DW7. That she was reading at that school. Okay.
Item 15. Item 16. Item 17 for motion. Item 18 for motion.
Yes. Yes. Opinion. Opinion complete.
Opinion is page, my lord, 60. Oh, no, not 60, earlier than, I was 56. Starts from 56.
Well. Yes.
I'll go through the record. Let me go through the records, my lord, there are some issues. Yes. Yes, 50, my lord, the return statement is an exact statement. This is my lord cross part. Orders. Yes, ma'am. Affidavit in shipment. 8 exhibits are there. Yes, this is the documents of exhibit 1. Yes, it's a photo. Yes, ma'am. Yes, ma'am. Yes. Yes.
My lord. 56.
What happened in this case, my lord? They did not submit evidence. They did not file evidence. No. No evidence was filed. This judgment was, the opinion was passed on 10/10/2018. And thereafter, this fact matter 19/8/2019. After delivery of the opinion, they have filed this petition. That these are these original documents, they may be allowed to bring these original documents. Take back. Take back the original. Take back the original.
Actually, madam, that was fixed for further evidence.
No, no.
Earlier- earlier-
Record has put up today learned advocate filed petition for taking back submitted original documents. This is for taking back original documents they filed on 19/8/2019.
This was Bhagavad Gita. Area se no tasa. Yete Juan, no tasa.
Evidence in shape.
Then we want to find.
Yes. Yes. This is not a statement, madam. The statement is recorded in the backside of the madam.
Application here, it is for a original document, you have to explain this. Who order that? Original is. Application program for. Document functional for original protection. Right. Return. Is the process.
We have tracked it. We have tracked the order sheet. And then also the cross-examine. Order sheet is mentioned that cross-examine in the charge. What's in the order sheet? Writing is very bad. If you can read it, you will find cross-examined and discharged. You've seen that? Cross-examined and discharged. It's very hard to read. Correct? Now the fact. The evidence is there. The back.
Yes.
This is a cross.
Further proof, further evidence.
Other evidence. The evidence, after the judgment of deputy editor, then the party asks for the
Original lordship. Okay.
It is there. I think that's the tribunal.
Yes, both. Both are in lectures. For going to the is clear.
Those way. These are legitimate, what are the-
26th August.
My lord, I may be allowed to see the records. May I please allow? Let's take that is that, prisoner's wife has been reported to the, my lord, as per affidavit submitted by the respondent number 11 lawsuit, petitioner's wife deported to Bangladesh in the night lawsuit in 30 hours. And others have not filed any affidavit. Service also completed in response of all the person, one private person is there.
Last page of
And diary,
My lord, I'd like to place the document. This is with to Mozahuddin Islam, no? Mozahuddin Islam.
Jamil is.
It is 9.
In the provisions of the title. This sentence says that he was brought to the 3.0.
Yes.
What happened for 3 years?
That, my lord,
To take it that all these for us. The case is not before technical innovation. And paragraph 1.
we'll file it, my lord, as your lordship has specifically directed to get a copy of this. That's why, otherwise we are ready to file the affidavit. And another aspect, your lordship has directed to, my lord, to file affidavit on 2 aspects. One aspect, whether my lord, the judgment, the opinion can be served on the day when he is detained. To that effect, we'll file an affidavit. We need some accommodation in that effect. This will file by.
Last order, my lordship's order, 17/7.
My lord, yes, my lord, that is another aspect, my lord, that is true, my lord, that I will have to look. Yes, my lord. So we'll file an affidavit, my lord. No, my lord,
Wife, madam. Children are here, madam. Children are here.
we will file affidavit, my lord, within 1 week to that effect.
And private respondent also notice, I
No,
think.
my lord, one thing, my lord, to that effect, I would like to submit. The respondent number 9, the member of the foreigner tribunal has been made party.
Yes. Has to be.
You
No, no.
see, in mind for police should not take someone.
No, my lord, at this stage, my lord, my prayer will be that may not be, because, my lord, if
This one, notice already issued to all, madam. Service complete.
let me file affidavit on this aspect, my lord, then 1 week time may be given, well, I'll file affidavit. Both aspect, my lord. The first of all, with regard to this document, apprehension, and secondly, my lord, whether your lordship's direction, my lord, observation, that the opinion can be served on the dead day when he is detained. Yes, my lord. No, that can be done, my lord. I also admit that can be done on the dead day. That is not a big issue. No, my lord, that is not true.
Circumstances indicate that.
Yes.
That is not only taken up, but the same day at
12:30.
that means you want to stop the packet from coming to us. That is the law.
No, my lord.
The deportation is sending back as per the revenue is on.
On 13/14 midnight, my lord. In the affidavit.
The second part is a problem. The tribunal is at full liberty to decide the case again and take its own view. No problem.
Exactly.
No problem.
My lord, to that, my lord, whether tribunal has directed to arrest him or not, that is different aspect. That is
In the presence of
That
the
is-
client, my lord, he
that is
telephoned the police
no,
station.
that is their, my lord, submission.
They are
That has to come on.
You have to defend something which are defendable.
No, my submission was, my lord, the respondent number 9. Before, let us file affidavit, if it is, my lord, on the basis of affidavit, our affidavit. It is, if it found to be necessary to be responded by respondent number 9, because
Otherwise, it will be, my lord,
In my
the,
decision, lordship, there are some specific allegations I have brought and the
yes,
affidavit.
affidavit, that's why, my lord, the allegations against, my lord, presiding officer.
Cannot defend them, I'm glad that because he's privately.
By name, he has been.
And our aspect is less important. What is more important is that, though there is no time stipulation, maybe some time.
There
that
is
should
no
also
time
be given.
stipulation.
But, a realistic chance should be given, even in criminal offences.
That is true, my lord, but
Isn't
in fact,
Person
the,
cannot
my
file
lord,
the writ petition
foreigner
and
elect, my lord, that,
on the next day, right?
yes.
But what you take in 19 or take 21?
1990. Yes. Yes, yes. 26. That will bring into record, madam. Those, everything will bring into record. Within 1 week, my lord, I'll tell it. I'll all this facts, my lord, I'll bring into record. Yes.
When lawfully sent back.
So those facts, my lord, I will have to bring, my lord, where she was, how she was, my lord, sending. No. Yeah. That patrol is. That was good. That is a problem. And I don't make it. 21, 29. Yes. This is probably the expulsion order, my. Please check with.
But under 1950 Act, it is not coming 50. Expulsion order 50. 50 is meant for some other purpose. Yeah. No, expulsion order, my lord, that question of expulsion, it is, that concept is not there at all, my expulsion. It is deputy commissioner has given some power, under 50 Act. Authorized officer. We saying. Yes. Last program. Let's do now. This is the. Yes, district commissioner, district commissioner.
Yes. Inspector.
Yes, that is there in the 50th one. But here is a case, my lord, what happened in this case, they have issued a SOP also government. In the SOP, kindly see SOP one that will, under our reputation is there, my lord, SOP. Only, my lord, SOP, what about the declared foreigners? One is, my lord, just as per 50 Act, and another is declared foreigner by the time. Second item, item 20, I'm saying. Yes, my kindly say 100, page 100 of item 20. The SOP starts from page 98. It is dated 29 October 25. Now your two good things are there. One is, my lord, just as under 50 Act, my lord, somebody was found and he was sent back. And about the 100, my lord, C, removal of declared foreign national. In the case of our standards. After exhausting all the things, then only they can do it. D. Roman law. C, Roman law. Page 100 in my in item 20. Removal of declared foreign nationals. So that is what they might have. No, they have stated, madam, once they have already exhausted the remedies available by accusing the High Court or the Supreme Court. That time ought to have been given to us, madam.
No.
It is your SOP. Similar from the time when I have taken, I had remedy to come before Law Street, before Supreme Court. After exhausting it is there, there SOP. They have not followed.
That point, my lord, will argue on merit, my lord, because the 1950 Act says, my lord, within 24 hours, they have to remove.
Yes.
So once declaration is made,
No, that is part.
the other, yes,
That is
once
part-
declaration is made within 24 hours, he has to be removed. Yes. Yes.
Two things are
So,
there. One is,
my lord, that's why I'm not arguing on that point, because. No conflicts. No, my lord, my lord, this is, SOP cannot go beyond the Act, my lord. The Act has provided, 1950 Act is clear, my lord.
SOP has two parts, madam. One part relates to the declared by the foreign tribunal. Declared foreign.
Yes.
Other side is under the executive order, my lord. Somebody is found here, he has come from Bangladesh or anywhere, then he is to be deported, put into deportation.
And the foreigners tribunal's
Yeah, in the
order,
case, but after exhausting all the remedy. Yes.
yes.
You
Those
have
are,
to
those
declare
are law
the
points,
time.
my lord, we'll argue on those law points. I'm not on those matter. Yes.
Yeah.
Let me bring on to the record, my lord, everything, my lord. Let it fix on 29, my lord. By that I'll file all the.
Already from 1960. My children one of these
Yeah.
children are crying for the mother. They should know at where she is.
Fixed, may fix on
Where she
29,
is.
my lord. I'll file, before that I'll file.
Let
the
them see it address to where they have pushed back. That I understand. That's fine. But we have come there to, they already said. And on the campus, my lord, she was there.
RB Boras.
Only 11 mark points. If you could find only 11,
Respondent number.
newly implemented we find. Huh? Yes.
Yes, sir.
Yes, sir. I will be sent. Yes, sir.
Pass. Yes, madam. You should have.
Only way to do different in this case, madam. In this case, madam, respondent.
Affidavit filed by respondent 11.
Only this way, madam, 5 by respondent 11, the same one, in their case it is 5, in my case 11, same person.
11 has filed affidavit.
The respondent was yes. In my case, it will be 11, right, respondent.
11 has filed affidavit.
5 is 11. What is happening?
Our party message.
11 is, your lordship, in my case, your lordship allow him to be included and to file affidavit. As respondent number 11, right? They put
Yes,
it-
sir. Yes,
Yes,
sir.
sir, fine. 11, right? Formality. Fixed, my lord. It is fixed on my
30th.
30. Right.
Oh, this is for you, sir. Lordship. If possible, tomorrow, Lordship. Lordship, tomorrow I will mention, it will be listed in Friday, Lordship. Lord. Lord.
Yes.
Lord. Lord. Okay. Lord.